Hello, my name is Judge Jessica O'Brien. I'm the president of the Women's Bar Association of Illinois, also known as WBAI. I'd like to welcome you to our very first ever cable show.
And our first guest for our session for this season is going to be Jill O'Brien. Jill O'Brien is a partner at Lane & Muchin. It's a 45 attorney firm that focuses on exclusively on representing employers, public and private, and employment, labor relations, and employment litigation. Jill is the hiring chairperson and a member of the executive committee at that firm. She joined the firm 25 years ago upon her graduation from John Marshall Law School, which is the law school that all of us graduated from. Jill is also the co-chair of the newly created Employment Law Committee of the Women's Bar Association of Illinois. And if you hadn't noticed before, we're all Virgos.
There you go.
Yes.
Jill, I don't practice in the area of employment law, but I have heard of the concept of at-will employment doctrine. Is there such a thing? Can you explain that to me, please?
Yes, the at-will doctrine is actually alive and well. And Illinois is one of the states, the majority of states, that do adopt the at-will employment doctrine. And in a nutshell, what that means is that every employee is hired for an indefinite duration. So basically, no promise I can fire you, no guarantees is basically what it is. I can change your pay, I can change your hours, I can end our employment relationship anytime, any reason, or no reason. I could literally say, the sun came up today, your employment's ended. And that is 100% lawful in at-will employment states.
Is that for all employees?
Well, the basic premise is everybody's hired as an at-will employee unless you're in one of the exceptions.
And what are those exceptions?
The most common exception would be, I made you a promise, I made you a contract otherwise. So everybody can be fired for any reason or no reason unless you and I signed a contract or I gave you an offer letter or some kind of a piece of paper that promised you I won't fire you for a year or I'll make sure you get promoted in 3 years. That would be an exception to the at-will employment doctrine.
Is union status an exception?
Well, actually, union status it connotes that there's a contract in place. Okay. So again, that's within the contract exception. In the union environment, there's a collective bargaining agreement as the contract, and that is binding, like any other employment contract, that is binding. And generally, there's what's referred to as a just cause provision. And just cause essentially means, you don't swear, you don't spit, you don't, violate our attendance policies. And if you do, that's just cause for discipline or discharge, okay? So certainly an employment contract as a written document is an exception, as is a union contract. The other more common exceptions would be you can fire anybody for any reason or no reason as long as it's not an unlawful reason. The most common we hear are protected categories, legally protected categories. So when I say legally protected categories, I mean age, which is 40 years and older. So you're not double protected if you're 80 and you're not.
This is great.
We're all protected.
We're all protected.
Yes,
barely.
Yeah.
So there's age, race, sex, which would be men and women.
Actually, I'm not protected.
I didn't think so. National origin, religion, disability, and that covers mental and physical disabilities. And that's basically protected categories. That's what I mean under federal law. Now, Illinois goes a little bit further. We also protect your status, your marital status, your status of being divorced, widowed, single, or married. We go on to protect rights for veterans and also in Illinois.
Sexual orientation?
Sexual orientation, exactly. Sexual orientation, sexual preference. And under the local ordinances, sexual identity as well has been for years and years one of the protected categories that we've recognized here locally.
Now, if I believe that I am in the protected category and I believe they violated it, what is my next step? Where do I go? What do I do?
Yeah, the best advice always is to take it in-house, okay?
What do you mean by in-house?
In-house meaning tell somebody you're upset. Okay? The basic laws on employment and discrimination are premised on the concept that everybody's entitled to a comfortable working environment. Okay? And the burden is on the employer to make sure it's comfortable. Okay? That means I have to make sure that you can come forward if you feel you're uncomfortable, but I also have to make sure that you're not making Patrice uncomfortable. Okay? So you have rights to complain, and you also have an obligation not to interfere with somebody else's rights. Okay? And people always ask me, well, what about my rights? I don't want to work with somebody who's not the same religion or the same, background as me or whatever it is. And when it comes to these issues, it's always going to be a balancing test. And my right to free speech, my right to tell a dirty joke, my right to have I use the example on St. Patrick's Day. People come forward in my office and they always knock on my door and want to ask me why I'm not eating potatoes and drinking whiskey in the streets. Okay? Now, one person could be very offended by that. You're making fun of my heritage. These are my grandparents that you're making fun of by making these stereotypical comments about my national origin. Personally, it doesn't bother me. And then it's who's right and who's wrong. You're just making a joke. Your intent, making a joke, is irrelevant under the discrimination and harassment laws. It doesn't matter what you meant to do. It matters, did it interfere with my right to be comfortable?
So when you say in-house, employees are always encouraged to resolve their issues with their employer first.
Exactly.
Okay.
And the easiest way to do that as an employer is to have a written policy that tells people, hey, we want you to be comfortable. And if you feel that somebody's invading your space, remember the old Seinfeld episode with the close talker that's invading your space? Yeah. You might feel that, somebody's in your space. You need to have a way to say, generally employers like you to say, knock it off. I didn't like that. Or maybe you thought that was funny. You didn't realize that that was over the line to me,
But isn't it true, though, that some employers are hesitant to have any written policies because it could be used against them?
Yeah, there are two schools of thought on that. And I would say 10 years ago, 10 or more years ago, there were people that would preach, don't put anything in writing, and then It can't be used against you. Nowadays, there's an actual affirmative defense to a claim of harassment if you do have an internal complaint procedure, okay? And the complaint procedure has to work, though. It has to have, alternate people to go to. So, for example, it's not effective if it says go to Judge O'Brien if you have a complaint, but then come to find out you're the one who made me uncomfortable. So I have to have alternate people to go to. And, you might want one man and one woman as part of your complaint procedure because sometimes women might feel more comfortable complaining to a woman, et cetera. Another feature is that, and probably the most important feature to be an effective policy, is that the policy specifically say, look, we won't hold it against you, we won't retaliate it against you if you come forward and raise your complaint with us. We just want to fix it. You're not trying to cause trouble, you're not trying to get anybody fired, you just want it to stop. And I'll tell you, in my experience, I'm sure there's exceptions, but I would say in the high 90%, the claims that I see on this type of a situation with a harassment allegation are because of a misunderstanding, or because I felt disrespected, or I felt you were mean to me, or you treated me unfairly, or you embarrassed me. It very rarely has to do with blatant harassment or intentional discrimination. It's usually you made me feel bad.
So in general, then, the written policies are helpful and also can be used as a defense in the future.
Exactly.
Is that correct? Okay.
Exactly.
Well, this is very interesting stuff. So let's take a break right now.
ended the last segment talking about written policies. Things are gradually changing, and so what I want you to talk about now is what are the current trends? What's going on that we should know about or should be concerned about?
Okay. Employment lawyers typically focus on statistics and trends and things like that the EEOC publishes. They do a report on an annual basis. The 2014 results from the Equal Employment Opportunity Commission showed that the number one type of complaint, 42% of all complaints, had some feature of retaliation attached to it. So even though I encourage employers to maintain a published policy and a complaint procedure, we need to also make sure your supervisors are trained and that they understand that they can get into trouble if they retaliated against somebody for exercising their rights. It seems obvious, but the law is very strict in terms of retaliation penalties, because the point is, if we're going to give you this defense that you can raise an internal complaint, we want to make sure that you don't hold it against the person for exercising their rights under the complaint procedure. So retaliation is definitely what all employers have their antennas up now.
Well, you said 42%. What's the other 58%?
Well, there's actually 42% of all claims
Okay.
have some feature of retaliation attached to it.
Right.
In terms of the protected categories, though, sex, gender-based claims make up 29% of the claims that were filed last year, so close to a third, and that includes pregnancy, and it would be male harassment or discrimination as well. Race is still number one at 35%. Surprisingly, the Equal Pay Act is also one of the laws that the EEOC enforces, and that's only 1% of all complaints that are filed. I think we've all heard about how women statistically make less than men, but yet that's such a small fraction of the number of complaints that are raised.
1% related to equal pay, for example?
Correct. On the Equal Pay Act alone. Now, that might be a feature of a gender discrimination claim, and so it's categorized as a gender claim. But I think it's a matter of many employees don't know about their rights under those laws.
But don't you think if I was working in a law firm, for example, okay, and I'm doing exactly the same thing as my man counterpart, and we graduated at the same time, we're the same top 20% of our law school, I wouldn't know if I was making less than him. And how would I know that?
It's very interesting because actually the law is very clear now, both under the Illinois Equal Pay Act and also the federal law, and also under the general labor relations laws. It is unlawful for an employer to maintain a policy that says you can't talk about salaries. Okay?
So I can just ask anytime?
You have a right to ask. Now, I'm not going to ask about Patrice's salary, who's not a comparable to me. She's my manager, and I want to know how much she paid for her new car. That would not be a proper inquiry. But if I want to say, look, I know that Jessica and I graduated the same year, we're doing the same responsible trials, I want to make sure that we're paid the same, you absolutely have the right to do that, and without fear of retaliation. I have a right to know. Most employers won't advertise that, let's face it.
But that's interesting, though, because in a law firm setting, of course, it's dependent upon your rainmaking capabilities. And so if my men counterparts they have big accounts and they have many more clients than I do, then they can justify giving him more money.
Exactly. And that is, in my view, typically what makes the differentiation in terms of the salary levels. Definitely at the partner level, where rainmaking is typically the key factor in terms of compensation factors. And you're absolutely right. There's no question that men tend to be better rainmakers. But what I have experienced is that women also love to refer business to other women. And so I think that's what's going to make the difference for us going forward, is to be more sensitive to the fact that we do have to help each other out. We do have to refer business to each other. And I know I'm preaching to the choir. I know that that's your platform for your bar year, is making sure that we do expose each other to different business opportunities and
promote each other.
Right.
Exactly
Most
right.
definitely. Now, Jessica was talking about pay equity. I'd like to look at a different aspect of payment in terms of salaries. Now Chicago has discussed a new minimum wage. How is that going to impact things in the future?
Well, the new minimum wage law in Chicago did become effective last week, July 1. I don't know when this is being taped, so I probably shouldn't have said that. But the new minimum wage law did become effective last week, July 1, and that was, it's now a minimum wage for all employers in Chicago to pay at least $10 an hour. Okay, and that's significant because it went from $8.25 to $10 an hour. That's a big jump for a lot of employees. And women do make up more of the workforce in terms of service positions that might be at the lower paying rates. So certainly that's going to be hopefully a big bump for women in terms of having a little bit more money in their pocket. The minimum wage law in Illinois, it progresses on an annual basis, starting now at 10. It goes to 10.50 next year, a year later 11, then 12, et cetera, and then it's adjusted by the Consumer Price Index. But the point is it has definite dates, and I can look now and say, at a minimum, if I keep this job, in 3 years from now or 4 years from now, I'm going to be $13 an hour.
How did they figure out the minimum wage though? Is that
Interesting.
Did they calculate that based on the cost of living? I mean, how was that calculated?
Oh, good question, and I wish I knew the answer. Oh, you just wait. I'm going to pay you back.
Now, and talking about the future, and you've talked about the timeline in terms of how much it's going to increase, and you've talked about recent occurrences. Since the United States Supreme Court has determined that they've made the Supreme Court decision about equality in marriage, how does that impact some of these wage issues?
As it turns out, the Supreme Court obviously was very much supported by Illinois and Chicago in particular, but that decision really didn't have an impact from an employment perspective. First of all, under the federal Obamacare, Affordable Care Act, that law already has required employers to provide same-sex couple the same benefits as opposite-sex couples.
Even if they're not married, right?
Even if they're not married. And in Illinois, we've always had, I say always, it's been only a couple years, but we do recognize marriage between same-sex partners. Even before that it was a civil union partners. But there are other laws that are impacted. For example, the Family and Medical Leave Act. That's a law that everybody can take 12 weeks off after the birth of a child, or if you have a sick parent, or if you have a sick child, or if you're sick.
Or if you adopt.
Or if you adopt, exactly. So under that law, you would be able to take it for yourself or for your spouse. And that's a federal law that's been around, but it only recognized, it was only recognizing same-sex spouses in those states who did recognize it, and very few states did. So I think that that's where we're going to see some impact. More people eligible for time off under the Family Medical Leave Act in other states, because more people are going to be now covered under that law. But from a discrimination standpoint, as I mentioned, Illinois and Chicago, we've always been sensitive to those issues as legally protected categories. Ironically, as it sits now, sexual orientation, sexual preference is not recognized as one of the legally protected categories under federal law. So it has big future impact, but right now it's basically not really changing Illinois laws very much.
Now, there was also some recent changes in the Fair Labor Standards with regard to overtime.
Right, and this is probably, in terms of trends, what we're seeing in my office as far as the most prevalent types of claims that are being brought against employers. Fair Labor Standards Act is the law that says employees, if you work over 40 hours in a week, actually work more than 40 hours in a week, then you get overtime, okay? We know that, the time and a half formula, okay? That's the premise of the Fair Labor Standards Act.
Well, Jill, I'm sorry, I'm gonna stop you for a moment because we're going to take a break.
Okay.
Thank you.
Technology is having a huge impact on my business. The entertainment community is not only delivering traditional movies and television programming, but using technology to create new messaging and new ways of building global communities. Technology creates large-scale opportunities. You can make powerful contributions as future entrepreneurs, content creators, employers, and employees. Believing in yourself is the greatest gift you can give to yourself. I believe in the power of technology to empower you. Tech needs girls. You can become the leaders who will bring about the change we need.
In our previous segment, we were talking about pay equity and parity between men and women in terms of salaries. What I'd like to ask you about now is what are the best practices that are occurring in the industry now? What is there to look forward to? What do you suggest to employers as well as employees in terms of employment law now?
Well, certainly one of the best practices would be, I'm a firm believer in having a document, an employee handbook, a manual that tells people what you expect of them. I think there's no question employees are more likely to meet your expectations when they know what they are. And everybody likes the praise along with it as well when they meet the standards. I'm also a fan of annual evaluations. Let people know what you're thinking, even though it doesn't necessarily affect pay. If I do an evaluation, it doesn't have to affect your pay. I do think it's important certainly to have your basic policies like your complaint procedures for harassment and discrimination, but I also think it's important to have a general open door policy. Employees certainly that feel more engaged in the workplace, more part of it, they can give their suggestions freely, they're more likely to stay and really contribute more and feel a part of it. If they feel like they're not part of the team, they maybe don't think twice when they're waking up in the morning. Maybe they don't mind calling in sick, or maybe they're looking for other jobs because they don't feel part of the team. So from a practical standpoint, you want to keep people, reduce your turnover costs and training costs.
Happy employees make
happy employers. Exactly right. Exactly
That's
right.
good.
It seems so fundamental. There was a time when I first started practicing, and people would say, do we really need an HR department, or let's put the HR department with the controller type person. And I think now there's a definite recognition in particularly the fact that human resources is an important function. Your employees are your most valuable tool or resource.
Now, is that true in terms of larger entities and smaller entities, or do you make a difference between what's more important in terms of process? Does a big company need HR as well as a small company?
Absolutely,
or not? Okay.
Absolutely. Certainly, perhaps more so even in the larger organization, because you'll want to make sure that things are consistent. I mentioned earlier the number one thing that I see in terms of the reason employees file claims is because they feel they were treated unfairly. And it might not have anything to do with their age or race or national origin or religion, but if you treated me different than Jessica, it must be because of an unlawful reason. It's what people think. People fill in the blanks. They assume that if something bad happened, it must have been unlawful. So consistency is critical. So that's another reason you want to have, uniformity in terms of your policies and a check system so that I can make sure that, the way I evaluate you is the same as another department is evaluating their employees, et cetera. I also, our firm is very big in terms of preventative issues. We all know one lawsuit could cripple an organization, a small company, and not to mention the bad press that goes along with it, or the bad morale from employees who, the gossip and everything else that goes along with it, plus the time involved in defending a single employment.
Time and money.
Yeah, the time and money,
right,
and frankly, it's, lawyer bills for even a single plaintiff case. So definitely prevention goes a long way, and I'm talking about basic training of the bosses, in terms of what their obligations are. If they learn of a complaint, the way the current harassment laws are, if I say, Jessica, I'd like to talk to you, I feel like I've been the victim of harassment, certainly we all know that's a complaint. But it also is, if you see me go, oh, Patrice, I can't believe you, I can't believe you did that again, I can't believe you said that, that's putting you as a boss on notice that I was made to feel uncomfortable at work. And in most cases, that's enough as if I tapped you on the shoulder and said I'm exercising my rights under the law.
Okay. And you talked about it from the employer's perspective. I know your practice is mostly for government, public and private, and so majority employers. Can you give any ideas to employees about what kind of position they need to take, or do they need to talk to a lawyer right away?
Well, I'm, again, as part of my preventative process, I'm a big fan in also training employees. And certainly a lot of our employer clients do respect that. Tell the employees of their rights under the policy and their obligations. There's a school of thought that I'm not going to teach them about the policies or the laws because then I'm going to give them ideas. I've never seen a claim filed by somebody who got the idea that wasn't going to have the idea anyway.
But transparency is always better anyway.
Absolutely right. Absolutely right. And frankly, as an employer, I'd rather know if there was something broken, I'd rather know about it early and fix it instead of waiting until it's out of control. But certainly utilizing your rights under the complaint procedures, asking the questions. I think that employers do encourage that now, and that's definitely what I'm seeing. In terms of, hiring a lawyer, that's certainly fine. The state and federal agencies, though, that handle these discrimination and harassment type complaints, it's a free complaint. You don't need an advocate to pursue your rights under those. Typically, the employer does have to be represented by counsel, but employees can file free claims at most all of these agencies, so you don't necessarily need a lawyer. One of the other things that typically employees will ask for is, it's wise to ask periodically to see your personnel file. Again, I'm not looking for trouble, but I want to make sure there's no surprises.
If there is one.
If there is one, and there's no obligation for an employer to keep the file. But I'd rather know there's nothing on me.
But you know what, Jill, as president of the Women's Bar, I'm very cognizant, we're all very cognizant, Judge Paul Reed here is also a past president of the Women's Bar. We're very cognizant of the women's issues. And so going forward, we've talked about equal pay. What can we do as an organization to address it? I mean, we've talked about how women are lagging when it comes to pay. What do we do? Enough of the talk. What can we do?
Yeah. Well, my own personal opinion is that there's kind of two buckets of factors that contribute to the pay gap. First, I think, is socioeconomic factors and, frankly, women's choices. We might choose not to work extra hours, or we might choose to go on a path of, I read a statistic recently that 92% of all kindergarten teachers are women. Okay? That's not a coincidence. That's because women choose that type of profession. There are definite factors and choices we make that do impact our salary. I'm not minimizing that. But in terms of helping each other, which I know is your real mission, I think that from my perspective, you're hitting it right on. And that is supporting each other. I'll use a law firm setting. Men tend to be better rainmakers because they have more friends that are business owners or whatever else it is that can refer them business. Women need to refer business to women as well. And I know in my experience, women love to refer business to other women, but we've got to support each other. And not only in terms of referring business, but supporting and praising and letting other people know about them. I have a great resource. I can't answer your question, but I have a great resource. And just mentoring, absolutely. And introducing, sharing your contacts. We're great at sharing friends and just making sure that anybody that I know that's a good resource, I'm introducing to you as well.
As well as exposure for women, which is what the cable show is about.
Yes,
and part of what we're doing this year, exposing women attorneys to businesses.
Exposing women like the superstar employment attorney.
It's wonderful, Jill. Yes, most definitely.
We're not related, but we share the same last name, the same birthday.
How about that?
Same law school.
How about that?
But thank you so much for being here
thanks for including me
tonight. We learned so much about employment law, and I'm sure that our audience, they're also learning a lot from you today. So I hope you come back and join us at another show. But Judge Reed, thank you for also inviting me to be your co-host. Welcome. This is a great idea. Again, this is her brainchild. I'm so glad that she came up with this idea. I think this will really give more exposure to our organization. One of my missions is to basically assimilate the organization, the Women's Bar, with the business community, the non-for-profit organizations, the political community as well, and the just the different areas that we can touch where we can talk about women's issues and promote each other in the women's community.
And to leadership positions. I love that message as well.
Well, thank you. As you know, my theme is leave no woman behind, not just for lawyers, but also other women in other profession, and empowering through leadership. I think it's, for me anyway, personally, and I think with you as well, that you're empowered when you're given the opportunity to lead. And that's why when we talk about leadership and employment opportunities, women should be given the opportunity to lead, to become managing partners. Those numbers need to go up. Don't you think?
Absolutely.
And you'll lead us the way, right?
There you go.
Okay. All right. Well, thank you so much for joining us this evening.